Hi, it's Kim Boon. My last video on Minister of State Gan Xiaohuang's handshake drew quite a bit of reaction. Some comments were heated, and I get it. Not everyone shares my softer stance. We all have different views shaped by different life experiences, and that's okay. In fact, it has to be okay if you want to become a more thoughtful, inclusive society. That actually reminded me of something that Miss Lily Kong, president of SMU, and what she said recently in an Inconvenient Question interview. As Singapore transitions to its 4G leadership, she spoke about a shift she hopes to see in how we speak to and about one another.
We need a citizenry that is open to different points of view, that is able to speak up in constructive ways, to move from criticism to critique to constructive engagement. It's easy to say, I don't like this, I criticize that. To critique it means to say, why don't I like it? What's wrong with it, in my view? And then to move from critique to constructive engagement to say, well, this is why I don't like it. How about considering this perspective for these reasons? So I would dearly hope for a citizenry that's able to make that shift.
I think we've come a long way from just shouting each other down. Take some of the comments I get. Sure, there are those who just tell me I'm talking nonsense, but many of you go further, explaining why you disagree. And that's what Professor Kong meant by critique. And what I really hope we can build towards is constructive engagement where we hear each other out, and even if we still disagree, we part ways with respect. Okay, mini detour over, let's talk about today's topic. As of last Thursday, Singapore has relaxed minimum penalties for dangerous and careless driving. Before we dive into the debate, let's clear up some of the key terms. Under the Road Traffic Act, there are two types of offences: careless and dangerous driving. Dangerous driving is more serious. It includes things like driving against traffic, not slowing down at zebra crossing, or driving when you're clearly unfit to do so. So depending on what happens, the consequences vary. So if someone gets hurt, it's categorized as causing death, causing grievous hurt, or causing hurt. And if no injury happens, it's classified as endangering lives. So what changed? So for first-time offenders, the mandatory minimum jail term and disqualification period have been removed. Even for dangerous driving causing death or grievous hurt, the mandatory minimum jail term is now lowered. Honestly, I thought it was a typo. So I read this update and I also listened to Senior Minister of State Faizal Ibrahim in Parliament explaining the changes.
With the removal of the minimum sentences for first-time offenders, we will make corresponding changes to lower the mandatory minimum imprisonment term for repeat offenders. Specifically, for dangerous driving offences causing death for repeat offenders, the mandatory minimum imprisonment term will be lowered from 4 years to 2 years. For dangerous driving offences causing grievous hurt, it will be lowered from 2 years to 1 year. This adjustment aims to create a more gradual progression in sentencing between first-time and repeat offenders under the new regime. The intent of these amendments is not to signal a more lenient stance towards repeat offenders. Repeat offenders will continue to be subject to mandatory minimum imprisonment terms and disqualification periods, and where warranted on the circumstances, the courts may in fact impose sentences higher than these mandatory minimum terms.
So let's talk about signalling. The government insists it's not going soft on offenders. But come on, the message being sent is not great, right? Even if it's unintentional. Let me give you an analogy. Say you're a dad and your teenage daughter brings a boy home for the first time. You might size him up, act serious just to send the right message. The second time, you're still wary, but by the fifth, sixth time, maybe you're offering him some snacks. You're not saying go ahead and misbehave, but you're definitely signaling that you're warming up to his presence. Same thing here. You may intend to remain strict, but the change itself sends a wrong message to potential traffic offenders. At the very least, that's how it feels to me as a citizen. But let's not get over dramatic. Let's just look at the data. These are Singapore's annual road traffic statistics published by the police. I'll give you a moment to take that in. You're probably thinking what NCMP Hazel Paul voiced during her response to the same changes back in January.
Members of the public have expressed concern about the removal of the mandatory minimum jail term and mandatory minimum disqualification period for first-time offenders, even in cases of reckless or dangerous driving leading to death. Drivers who run red lights or drive recklessly at dangerous speeds are knowingly and willfully putting other road users at risk. In justifying the amendment, the Ministry of Home Affairs have shared several examples where the current laws as applied would be too harsh. Many Singaporeans are baffled by the timing of this decision to do away with mandatory minimum penalties. Online and offline, many members of the public have shared that the proposed changes would make the roads feel less safe for themselves, especially pedestrians and cyclists, and are concerned that the change will lead to a rise in the number of dangerous driving cases. These concerns are understandable given that there has been an increasing trend in the number of fatal accidents in recent years.
Now, in fairness, there is a reason for this legislative move. It gives our judges more flexibility in sentencing, which is a good thing. I actually agree that courts should have more discretion to weigh the facts of each case. But context matters. Singaporeans often accuse the government and by extension the PAP of being tone deaf. I don't always agree, but sometimes they really do bring it upon themselves. Judicial flexibility is good, but why roll it out now? Why choose this backdrop when fatal accidents, injuries, and even drink driving violations have been steadily increasing since 2020? It's a little like this. Your colleague quits, you've been covering their work flawlessly for 6 months. You earn a pay raise, no doubt. So you decided to ask your boss for an increment after lunch. But during lunch, you spot him having a heated fight with his wife at a quiet cafe and he storms off. And when you're back in office, you go up to him right after and ask for a raise. Would you do that? Probably not, right? But that's what this law change feels like. Bad timing, wrong tone, unfortunate optics. But now, to be fair, SMS Fajar did point out that in some cases, the courts had no choice but to impose unnecessarily harsh sentences.
A taxi driver who is a first-time offender beat a red turning arrow signal and collided into an oncoming motorcyclist who was speeding across the junction on an amber signal. As a result of the accident, the motorcyclist had pain, scratches and abrasions to the neck and shoulder and received a total of 25 days of medical leave. If the taxi driver is convicted for dangerous driving causing grievous hurt, the current law requires the courts to impose a minimum of 1 year imprisonment and a minimum disqualification from driving of 8 years. However, it can be argued that the taxi driver is not as culpable because the motorcyclist had been speeding across the junction on an amber signal. The accident might not have occurred if the motorcyclist had slowed down and prepared to stop when the traffic light turned amber. The government's view is that the court should have the discretion to decide if a lesser sentence would be more proportionate to the culpability of the taxi driver and the extent of injuries suffered by the motorcyclist. Put simply, in circumstances where the victim had also contributed to the accident, the court should have the flexibility to impose a sentence lower than the current statutory minimum.
That's a real concern, but now we're stuck between two priorities: ensuring fair treatment for minor offenders, sending a strong deterrent message to protect the public. If I had to choose, I'm okay erring on the side of protecting the public, especially when it comes to repeat offenders. And what disappoints me most is how the government's stance seemed to have shifted since 2019. Back then, we strengthened the Road Traffic Act, we were firm and clear.
Take, for example, the case of the 62-year-old rag and bone lady who I mentioned earlier, and she was killed by a drink driver. The offender had been drinking for 9 straight hours and was charged for the offence of causing death by a rash act. During sentencing, also taken into consideration were 1 count of drink driving and another count of causing grievous hurt to the dead victim's husband by a rash act. In all, against a maximum penalty of 5 years imprisonment, he received a jail term of 10 months and disqualification of 8 years. Many people felt rightly that the motorist was let off too lightly. Traffic police and LTA have taken steps beyond enforcement. Engagement and education do help to rehabilitate errant road users. However, where an act is dangerous and causes harm to others, we should not let it go lightly punished. Doing so will only undermine our road safety regime. Mr. Speaker, this bill is necessary to help make our roads safer by enhancing deterrence against irresponsible driving.
Now, in 2025, we seem to be pulling back. Yes, flexibility for judges is important, but when it feels like you're sending the wrong message to would-be offenders, I think we've crossed the line, especially when traffic situation is clearly worsening, not improving. And it's moments like this I wish I'd gotten more involved earlier. Public feedback on this bill closed in the last quarter last year. The decision in Parliament was made in January 2025, and now it's done. So this isn't a discussion anymore, it's law. But here's the thing, it's not just the law that changed, I changed too. And this episode reminded me that policies aren't abstract. They shape lives, and they signal what we value, what we can tolerate, and who we're willing to protect. And it pushed me to reflect not just on what our leaders are doing, but what I am doing as a citizen. And maybe that's the uncomfortable truth, that sometimes it's not just enough to just point out what feels wrong, but we have to make noise of our own. Not noise for the sake of it, but the kind that asks questions, pushes back, and shows up, even if it's after the fact. So here we are with a law that's already changed and the public still catching up to what it means. I'm not here to tell you how to feel. Maybe you agree with the changes, maybe you're uncomfortable with them, and that's fine. But if there's one thing I hope we can stand for, is this: that we don't sleepwalk through policy decisions, that we don't wait until things are passed to ask the hard questions like I did, that we stop outsourcing civil responsibility and start owning a piece of the conversation. Because that's how we protect the kind of Singapore we want to live in, not just for ourselves, but those we share the roads with and the country with. And if you're still watching this, it means you're part of the conversation, and I thank you for that. And if you found this useful, share it. And if you disagreed with me, tell me why. But above all, let's keep talking. So I'm Kian Boon, and until next time, this is our Red Dot Perspective, and I'll see you at the next episode.